there was a decision by a federal judge by the name of, what the hell is his name? Timothy Kelly. And in every article they say he's a Trump appointee, a Trump appointee, a Trump appointee. Have you noticed when they're left-wing appointees of Obama or Clinton, they never say that. I've pointed this out to you before. Again, I want to educate you about something because the New York Times, the cable TV networks, the other networks, the Washington Post are not going to tell you what I'm telling you. But as somebody who served in the Justice Department under Reagan and somebody who served in the White House as Associate Director of Presidential Personnel under Reagan, handling, among other things, federal judge and nominations, the federal district courts, even though a President Trump or a President Reagan or President Bush or whomever may make nominations, typically what happens is the senators from the home states make recommendations. And if there's 2 Democrat senators from these various states, or it's a Democrat area, there has to be some horse dealing. So let's say there's 3 vacancies. A Democrat senator will say, okay, I'm going to filibuster that, or not anymore. What they'll say is, I'm going to hold that up, I'm going to do this, I'm going to do that. So sometimes a president has to say, all right, these are the 2 I want, you can get 1. Now, this is why, even when they report this, they call the judge, Timothy J. Kelly, a Trump appointee. This is why they never tell you the background. Well, is it actually a Trump appointee, or was this part of a deal? I have no idea. That's a side point. It's not really that substantive, but I want you to know how this horse trading works. It's not the same on the appellate courts that is the circuit courts, where an administration doesn't do horse trading. And it's certainly not the same when it comes to the United States Supreme Court. Now, we have a ruling from this Judge Kelly. Let me read from the New York Times. Stay with me. You're going to learn more than anybody else. Michael Grinbaum and Emily Baumgartner, whatever, 400 letters, what do you expect? I can't pronounce it. A federal judge on Friday directed the White House to restore the press credentials of Jim Acosta of CNN. A win for media advocates and news organizations in a major legal test of press rights under President Trump. Now, let's stop there. The judge issued a TRO, a temporary restraining order. I don't know how he did it. I don't really know why he did it. It's a 14-day emergency order. That's what a TRO is. Not a permanent injunction and so forth. And to get a TRO, you have to show a heightened level of threat to the public, health, safety, that sort of thing. So this judge issues a TRO. So we went into the usual places to look for his ruling, right, Mr. Producer? I looked, Mr. Producer looked, my wife Julie, who's a lawyer, looked, we asked somebody else to look, who's been a paralegal most of her life, and we all looked, and we couldn't find it. So this was a ruling from the bench. It was not a written ruling. There's no written order. A ruling from the bench. Now, the irony here, ladies and gentlemen, is there's no cameras in this courtroom. To my knowledge, there's no broadcast equipment of any kind for radio and so forth. So, you and I were left out of the courtroom. You and I were left out of the information flow as it took place. Because federal courts don't allow television cameras. And so we have a judge ruling on whether or not a showman for a news network has a constitutional right to a hard press issued by the President of the United States. And this TRO suggests, although there's no constitutional underpinning yet, because he avoided that altogether, that he might. But you and I have no idea exactly what took place in that courtroom. We, the American people. The media are going around telling us what took place in that courtroom. but not you and I. Now let's go beyond that. So we contacted the court, and what happened? Well, let's see here. I'm looking at our email scheme here. We contacted the court, and we said, okay, how do we get a copy? Did somebody make a transcript of what took place? Yes, somebody did. The court reporter. They have a court reporter. They made a transcript. Okay, is it posted somewhere? The transcript of what took place in oral argument, is it posted somewhere? No, it's not. Wait a minute. It's not publicly posted anywhere? It's not publicly posted. Well, why not? Well, we're not going to do that for 90 days. 90 days? Okay, you're not going to do it for 90 days. However, they said, if you want to buy it, you want to purchase it at the end of the day or, the rest of next week or so forth, we'll sell it to you, the court says. You'll sell it to us? Yes. How much is it? It's $1.25 a page. There's about 18 pages. So it's a little over $20, and I might get it at the end of the day? Well, these are expenses for the court, we were told. I was specifically told this. Well, that's fascinating. And we were told you can go online, the district court in the District of Columbia. We got the address, the URL, and we looked at it. And here's how you get it: transcript, order, directions, and information. A, to order a transcript, please complete the requested information below in its entirety. You may select the appropriate court reporter from the drop-down menu below. If you do not know the name of the court reporter, please consult CM-ECF or PACER and review the docket entries to determine the correct court reporter. B, transcript rates can be found by clicking on the maximum transcript rates link. All transcript rates are per page. C, after receiving your completed request form, the assigned court reporter will confirm all transcript requests by return email within 2 business days. For urgent requests, hourly or daily, or if you've not received confirmation of your transcript request within 2 business days, you may call the court reporter directly or contact the main office. D, former court reporters who are no longer employed at the U.S. District Court are still responsible for producing requested transcripts, and it goes on. Now, what do they want? You pick the court reporter. You have to pick the date of the proceeding. You have to pick the case title, the case number. Then they want to know, indicate the status of the ordering party. Do you have a lawyer, a court-appointed lawyer, a pro se party, U.S. attorney, DOJ attorney? Whole list. Is this case currently on appeal? Yes or no? Is this a CJA request, Criminal Justice Act, court-appointed attorney? Is this an FIN-1 request, U.S. Attorney's Office request? Is this an FPD request, Federal Public Defender's Office? Name of ordering attorney, firm name, firm address, name of contact person, phone number, extension, email address, confirm email, notice. I agreed to and understand the following. All delivery requests must be pre-approved by the assigned court reporter. You may also goes on and on. If you want to know what took place in that courtroom and want to read an actual copy of the transcript of the judge's proceedings in that courtroom over this matter where the people have the right to know, they tell us, you'll have a hell of a time getting it. The vast majority of the people reporting on this today have not read the transcript unless they were in the courtroom. Isn't that amazing? There's no TV in the courtroom. There's no public transcript of what took place in that courtroom. There's no radio audio of what took place in that courtroom. Nothing. So while I would like to analyze what the court said and did other than a few sentences in the media, I can't. We're told in the media that he did not address the constitutional issues, but he did address the due process issue. Due process? And that the White House now is having to prepare procedures for reporters, maybe a code of conduct that will be applied to reporters. So this federal district judge who conducts himself in secrecy, at least away from the American people, making it extraordinarily difficult for you and me to know what the hell took place in that courtroom. That federal judge, one judge out of 1,000 federal district judges, has ruled that the President of the United States can't yank a hard pass from an individual who conducts himself in a very inappropriate way in front of the American people, in front of the rest of the press corps, and in the White House. Even though CNN has approximately 50 other so-called journalists with hard passes. Unbelievable. This is why I want you to stay with me. I will explain these things. So we don't have a transcript of what took place in that courtroom. And so I said to the court reporter, well, why don't you tell the judge who I am, that I have an audience of millions, that we'd like you to put it up for free on a site where the people can see it. And he would have none of it. Freedom of the press, baby. Except when it comes to the federal judiciary, that's a fact. And nobody will be calling this judge Hitler, Stalin, a fascist, anti-free speech. In fact, he's being celebrated today. He's being celebrated because the egomaniacs and the narcissists in the media, all across the media, all across it, are claiming a victory. The American Criminal Liberties Union, ACLU, claiming a constitutional victory. Now, of course, the President of the United States is not required to even hold a press conference. The first press conference was held by Woodrow Wilson in 1960. The President of the United States is not required to call on any particular reporter. But apparently, it would appear, we don't know for sure 100%, but if you look at the temporary restraining order, that is the result, not the rationale, because one hasn't been written and we don't have a copy of the transcript. But the president does not have the power to yank a hard pass unless he creates some kind of process that the court approves of. This is a clear violation of separation of powers. I don't know who this man is in black robes, got a lifetime appointment. This Timothy Kelly. But I will tell you now, despite what the mob in the media say, despite what the mob in the law schools say, despite what the mob on cable TV says, this is utterly and completely unconstitutional. And I don't need some jerk who was recently appointed to the bench or some jerks who take up the case for CNN and turn this entire process on its head, a very dangerous thing, to lecture me or you. And when I come back, I'm going to show you additionally how absolutely ridiculous this is. We'll be right back. Now, do you think the courts are actually protecting reporters? No. The court's not really protecting reporters. How do I know this? There was a case in 2005 involving the former New York Times reporter Miller. You'll see her on Fox from time to time, Judith Miller, and also Matthew Cooper. I believe he used to write for Time magazine and other newspapers, New York Times, I think, as well. Well, they and individuals who leaked information to them were under criminal investigation by the Department of Justice. Both were served with grand jury subpoenas to testify in front of a grand jury and to provide their notes and any documents involving conversations with any of these official governmental sources who had apparently been leaking to them. And this related, you might recall, to this Valerie Plame. Miller refused. So a federal judge in Washington, D.C. held her in contempt, held Cooper in contempt, civil contempt. He refused too. They appealed to the D.C. Circuit Court of Appeals. They claimed that under the First Amendment, freedom of speech, they had what they called was what a reporter's privilege. The appellate court in Washington, D.C. said, no, you don't. they upheld the district court's decision. And they were both sentenced to 18 months in prison. Then they appealed to the United States Supreme Court. The appellate court's decision was stayed, that is, held until the Supreme Court would rule. The Supreme Court wouldn't even hear the case. And Miller spent, I believe it was 4, maybe 5 months in prison. In the case of Cooper, I seem to recall his source released him and allowed him to provide the information so he could comply with the grand jury subpoena. There is no reporter's privilege. The federal district court, the federal appellate court, the federal Supreme Court, were they called dictators? Was it said that the judiciary violated the First Amendment and freedom of press? No. The President of the United States yanks a hard pass from an individual who is a showboat, who is disrupting a presidential press conference, from an individual who's not even asking tough questions, but is being enormously disruptive and argumentative and provocative. Self-promoting, if you will. And the media in this country, including Fox, the Associated Press, which was under investigation by Obama, USA Today, and others, circle the wagons around Jim Acosta. And they claim that this could be the beginning of a police state. One of the filings, I forget which one of the friend of the court amicus filings said, what about Khashoggi? Khashoggi? These are not serious arguments when pulling a hard press pass, when there's still 150 reporters in the room, when there's still 50 CNN reporters with hard passes. And so, of course, this is why I wanted a transcript. I wanted a transcript so I could read it to you tonight of what this judge had to say. Timothy Kelly, whoever the hell he is, I wanted to read it to you. Because we have a big problem in this country with these judges. My first book was called Men in Black, How the Supreme Court is Destroying America. It should have been How the Federal Judiciary is Destroying America. Not if they adhere to the rule of law and the Constitution and so forth. But the problem is the courts have also been conquered by the progressives. That's what the activists are. And it takes a very strong federal judge to stand up to this, particularly to stand up to all these media outlets that have the power to destroy his or her reputation, his or her character. It takes a lot of power to stand up to that, to stand up to the media mob. And apparently, at least so far, this judge can't handle it, in my humble opinion. Because the arguments made by Ted Olson and Ted Boutros were almost childish. They were superficial. And, of course, they intentionally left out numerous factual matters, pieces of information, in writing the piece of advocacy that they wrote. So we have another decision by another court intruding on the executive branch, violating separation of powers. There's a good piece in Conservative Review by our buddy Daniel Horowitz. He kind of builds on my point. I'm not saying because I talked about it, but he's building on the point about judges. He says, if a single judge has the power of God and can redefine marriage, create a right for 7 billion people to immigrate, and create a right to 30 days of early voting, there's literally nothing a court cannot do. And he's pointing out what courts have done. If someone can force his way into our country and litigate rights and citizenship for his kids against the national will, why can't an American opinion journalist force his way into the White House? I guess I can now obtain a press pass as well, he writes. Whatever process occurred within the government is still so shrouded in mystery that the government could not tell me at oral argument who made the initial decision to revoke Mr. Acosta's press pass, said Timothy Kelly of the U.S. District Court of Appeals, according to a reporter, I suppose. Well, it's pretty ironic, Judge Kelly. Pretty ironic that you would write something like this when your own courtroom will not release to the American people what took place in your courtroom today. The irony of irony, sir. Now the president must publicize a process for press badges. Just as the courts tell us he must show his work on who gets to come into the country. This injunction, or I'll say a TRO by a Trump-appointed judge, proves every thesis he says I've been posting about the judiciary since I started this column and wrote my book, Stolen Sovereignty. I think it also underscores my book, Men in Black, that was written in 2005. Once we erroneously agree to a judicial supremacism and to the notion that a single district judge can order the other branches of government to take the most absurd actions, we no longer have a republic. We have a judicial dictatorship. Good job, Judge Kelly. Once we assent to judicial supremacy, there's no way to win the judicial game. Even so-called conservative justices have fundamentally accepted, to varying degrees, the contortion of fundamental rights has been accepted by the legal profession. Very few of them are like Clarence Thomas. Merely appointing better judges without dismantling judicial supremacy will not help. There's enough existing toxic jurisprudence in the legal culture to destroy a republic 10 times over, even if we don't add to it. Absurd conservative lawsuits would be tossed out immediately, but there's no level of absurdity for a liberal lawsuit that will bar it from at least getting standing and obtaining a temporary restraining order. We saw this with a bunch of immigration lawsuits in the global warming case. Once their absurdities are legitimized in the system, even if they don't ultimately win on the merits the first time around, they will eventually become the law of the land. There's literally nothing that a court can do that will elicit a red flag from the body politic. A single district judge has more power than the House, Senate, President, 50 state governments, and our entire history and traditions put together. At its core, what we are seeing today runs much deeper than the outcome of a press badge for one highly paid professional protester. This is why I condemn Olson. This is why I condemn Boutros. This is why I condemn the pseudo-conservatives who defend this. And this is why I denounce all of the news organizations, friend or foe, that have gotten involved in this case. We have a judicial system that has flipped the whole concept of fundamental rights on its head, so that a real right is violated, but a privilege is treated like an inalienable right. So you don't have the right to your own property and conscience, not to be forced to serve a same-sex marriage wedding. But someone else has a right to involuntary servitude. You don't have a right to pray in public, but you have a right to access the White House. Anyone living in, say, Somalia has a right to immigrate. And illegal aliens can sue law enforcement and win civil damages against them because they merely follow the law. It would be bad enough in any branch of government held such views on the foundation of fundamental rights, but the fact that our political system regards the courts as supreme to the other branches essentially makes us a judicial form of North Korea, writes Horowitz. We're told there's nothing we can do about it. A right is the principle that we are entitled to live without government applying actions against our lives, liberty, or property. And as Sam Adams added, together with the right to defend them in the best manner they can. Seeking a visa, a marriage license, or a press pass is a positive privilege that you're seeking from the government. They are not fundamental rights. We've talked about this before. Merely being left alone and being allowed to run my property according to my conscience and defend it with a weapon are fundamental rights. And Clarence Thomas explained this point as in dissent in Obergefell. He said the court's decision today is at odds not only with the Constitution, but with the principles upon which our nation was built. Since well before 1787, liberty has been understood as freedom from government action, not entitlement to government benefits, wrote Thomas, in response to the court creating a right in the recognition of same-sex marriage. And he concluded, our Constitution, like the Declaration of Independence before it, was predicated on a simple truth. One's liberty, not to mention one's dignity, was something to be shielded from, not provided by the state. Which brings us to this other point. Even if one wrongly posits that the courts have the final say in vetoing a government action over a broad political question, that would only apply to negating and overreaching action of the government, but to demand that the government take a definite action left up to the executive branch, not the judiciary, such as granting a visa or a press badge, is beyond any scope of judicial power. What you saw today, although we don't have the transcript, but it's a result of this judge's oral opinion, is judicial tyranny. I've talked about it. I've written about it for decades. Judicial tyranny. That's what CNN brought you. That's what Jim Acosta brought you. That's what Ted Olson brought you. That's what Ted Boutros brought you. And that's what all those friend of the court amicus brief brought you. They don't care about the Constitution. They care about themselves, their own celebrity, their own ratings, and their own profits. I'll be right back.
Mark Levin.
Why do I care what Michelle Obama has to say? Does anybody care what Michelle Obama has to say? She's gone through the same celebrated media interviews as Jim Comey, as all the rest. And, of course, I, as First Lady, I never directed that somebody should be fired or removed at the White House. Really. But as an ex-First Lady, you're doing things that ex-First Ladies aren't supposed to do. That doesn't seem to bother you. As a First Lady, your mother lived in the White House. That was kind of weird and different. Nobody really complained about it. I mean, there's a lot of weird stuff you did. And you're, in my view, a very hardcore left-wing radical, just like your husband. You're both now worth, what, $100 million? And you're still against the system, fighting the system. And she charges a fortune, by the way, to come see her speak. A fortune. She doesn't say, I want poor people to come watch me speak. I don't want to charge anything. No, she charges a fortune. Now, none of this hypocrisy has been reported by Jim Acosta. I might point that out, too. Well, ladies and gentlemen, I thought I needed to take the time to go through all that, because if I don't do it, nobody else will. Let's be honest about it. The Holocaust-denying New York Times has it all wrong. The cable shows are barely explaining what took place in that courtroom because they don't have the transcripts. Neither do I. I'll be right back. You know, I've got a ton more on Acosta here, but I'm done for now. I'm not going to do more on Acosta here because I think I've analyzed this better than most. And for you to listen to what all these people have to say is really of no consequence. Jim Acosta, Brian Stelter, who's another nobody, Jim Sciutto, this guy worked for Obama, now he's at CNN, Whoopi Goldberg, dumb as a doorknob. Now, the President of the United States had something to say, and on Sunday he'll be on Chris Wallace's show. So let's take a little peek at this, then we'll move on. Cut 5, go.
A federal judge who you appointed has just ruled that
Now, let's stop. Now, I also explained how the district court appointments work. Okay? Go ahead.
CNN reporter Jim Acosta his press pass back. Your reaction to the ruling?
It's fine. I mean, it's not a big deal. What they said, though, is that we have to create rules and regulations for conduct, et cetera, et cetera. We're doing that. We're going to write them up right now. It's not a big deal. And if he misbehaves, we'll throw him out. Or we'll stop the news conference.
What are your rules going to be? What is it that you're saying?
They're doing them now.
This is over the line, and you use your
they're doing them now. I mean, we'll have rules of decorum. You know, you can't keep asking questions.
You know, this is so sad that we have to have rules of decorum for media types. They're so out of control. We have to have rules for decorum. Some federal judge has now dictated to the President of the United States that you have to have rules for decorum or you can't pull a hard press pass. Nothing like this has ever happened in American history. Nothing. Presidents putting reporters in jail, which I absolutely oppose, but that's not the point. Just incredible. So now a hard pass to the White House is a constitutional right for a reporter. Now think about how ridiculous this is. I mean, the White House makes decisions every day about which reporters can come in, which reporters get a hard pass. Everybody who claims to be a reporter can't get a hard pass. We're going to base it on ratings, on audience size. This was a conduct-based issue. So the judge really blew it. He really screwed up. Again, I'd like to read what he had to say, but he really blew it. And he said, the government can't even tell me who first decided that this guy should have his press pass pulled. Well, why does that matter to anybody? Why is that a constitutional matter? In the end, the president makes the decision. There's all kinds of decisions a president makes. We don't know who initially came up with the idea. It's of no consequence. And a judge doesn't have any right whatsoever to look into that. None. To even ask questions about it. Go ahead.
Reporters in that room, many reporters in that room, and they were unable to ask questions because this guy gets up and starts, doing what he's supposed to be doing for him and for CNN and, just shouting out questions and making statements, too. But I will say this, look, nobody believes in the First Amendment more than I do. And if I think somebody's acting out of sorts, I will leave. I'll say, thank you very much, everybody. I appreciate you coming, and I'll leave. And those reporters will not be too friendly to whoever it is that's acting up.
And that's the point. I mean, this doesn't serve the American people. It serves the press, not freedom of the press. The purpose of freedom of the press is to promote free speech among the citizenry so we can get the information, so we can speak to each other, so we can share our thoughts and our ideas. This is a republic. Freedom of the press is one little tiny piece of it. It's a very crucial piece. And so we now have these massive media corporations that hire these hot dogs who are all looking out for their own agenda. They want to go on these nighttime shows. They want to go on the speech circuit. They want to be recognized. They want to go Hollywood. That doesn't serve the American people. Major Garrett is the CBS White House correspondent. I had lowered his rank to, you may recall, Mr. Producer, to Private Garrett. But now I'm going to bring him back up to Major Garrett, because he had an interview with my buddy Larry O'Donnell, who is a great radio host here on WMAL. And he's Larry O'Connor. Who did I say? Yeah, Larry O'Donnell? No, Larry O'Connor. And he is my buddy. And, Larry O'Connor raised this issue with now Major Garrett. And Major Garrett said, look, my job is to ask questions, but really I'm not the news, and I try my best to make sure that it's not about me, that it's about the news. Now, that's the point, Judge. That's the point. So they'll fight it out. They should appeal it. They should go all the way to the Supreme Court and force the Supreme Court to force the president, that's what they're going to do these various things. But I want to encourage bloggers out there and others, bring lawsuits. And bring lawsuits in court against the very court you're in and demand TV cameras. Demand that the court be open to the public. Demand TV cameras. Because the most significant way information is shared with the American people is through radio and, yes, television. So we should demand TV cameras in the court. I don't like it, and I oppose it, but still, I want us to be consistent. We have a right to know how these courts operate. We have a right to know how these judges operate. I don't care if they have lifetime appointments or not. As a matter of fact, especially because they have lifetime appointments. We have a right to participate in the judicial selection process. These court decisions affect all of us. So, I mean, the president, compared to the courts, he's an open book. So the idea that he has to have this reporter, who is a Hollywood, fabrication, if you will, a creation, is really so ridiculous. That's why I went through the difficulty I had in getting a transcript out of this court on what took place.